Okay, we're going to go ahead and get started. We have some attendees and I expect a few more to trickle in, but we'll go ahead and get started with our webinar today. So welcome to our webinar. I'm Melissa Rosenberg and I'm here with Michelle Dellino, who is the owner and managing attorney and founder of Delena Law Group. And today we're going to be talking about different approaches to divorce. So we're going to deliver some content about what's going on here. And the different approaches to divorce and some tips, and then we'll take questions as well. If questions come up while we're delivering content, please go ahead and put them in the chat. You can put your question in the chat. You can make it anonymous if you'd like, but know that the chat questions or the Q&A, either one of them, will only be coming to me, the host. So they're not going to be publicized for the whole group. So go ahead and put your questions either in the Q&A or in the chat. Either one would be fine. And I'll keep an eye on those and make sure that we try to get as many questions answered as possible. So I'll let Michelle further introduce herself in just a moment. I'm Melissa, and I am a licensed therapist specializing in relationship transitions. I work with a lot of clients, both individuals and couples who are contemplating divorce or going through the divorce process. And it's, really helpful to be able to collaborate with the attorney team over at Dellino Law Group and support our clients as best as possible. I have my private practice on the side of the law firm, and I work with people who are not involved with the firm as well, but it's really a wonderful collaborative approach to be able to deliver wraparound supportive services to the clients who need it. So that's a minute about who I am, and I'm going to let Michelle further introduce herself and start in on our topic today. Thank you.
Great. Hi, I'm Michelle Dellino with Delena Law Group, and Delena Law Group's a full-service family law firm. We have 5 family law attorneys. We deal with all aspects of family law, not just divorce and separation, but obviously a big part of what we do is divorce and separation. So Delena Law Group has offices in Seattle and Bellevue. We help people in King, Pierce, Snohomish County, also Thurston, Kitsap County, kind of all around Puget Sound, deal with their family law issues. And our approach to divorce, it takes a lot of different forms. Pretty much just like relationships, divorce is not universal. So sometimes you have to deal with things in a more collaborative way. Sometimes you use a cooperative approach, and sometimes you have to litigate. It really just depends on the particulars of your situation. No marriage is the same, and unfortunately, no divorce is the same. So that's a little bit about me and about our approach. One of the things I think that makes our practice a little bit different is that we focus on client communication. So a lot of the time when people work with a lawyer, they might not hear back from their lawyer for long periods of time. We focus and we really strive that our clients always know what's going on. They know what to expect. They know what's coming up, and they know that we're going to be with them every step of the way throughout the process. So a divorce and a separation can be a really scary process. It's not something that you ever thought that you were going to encounter. And a lot of the time, you don't know what to expect. You don't know, am I going to end up in court like I've seen on TV? Am I going to end up sitting around, a table with my soon-to-be former spouse trying to hash out how this is going to go? What's this going to be like? So today we're going to talk about different approaches to divorce and what that might look like for you, and sort of how to figure out where do I fit into the whole scheme of things and what my options are. So like Melissa said, what we'll do is I'm going to go through the kind of 3 main different approaches, because there are 3 different approaches, and talk about those in a little bit of detail. First, I'll talk about some ways to think about what approach might work for you before I get into those different approaches. We'll take some questions if you have any, and let you know, a few tips that might correspond as well as you begin to think about these things. First of all, everybody comes to the divorce space at a different stage. It's important to know that when people start to think about divorce or separation, because not everybody's married, this applies to unmarried people as well. In Washington, it's notable, unlike other states, that whether it's unmarried parents or just unmarried couples that have been together in what is known as a committed intimate relationship, that those relationships can also be dissolved through the court process. And in a lot of instances, they need to be, because there might be assets that need to be divided, and those can be divided between unmarried couples in Washington, or there might be a parenting plan that needs to be entered. So those things still need to go through the court process, and you still might need to go through this kind of process. So when you start to think about things, the question is, how long have you been thinking about divorce or separation? Are you at the point of thinking, this has to happen right now? I'm ready to file paperwork. I'm ready to move out. I'm doing that. Or have you already separated? You're already living separately and you're just really ready to sort of metaphorically, I guess, pull the trigger and tell the world, I'm starting this process, we're filing something, we're really doing this, and we're separating assets, we're we're establishing a custody plan? Or have you not even spoken to your spouse about it, you're still living under the same roof, and you're just thinking, I'm really unhappy and I want to know what this could look like if I went down that road? It's really notable that the average person thinks about divorce for between 2.5 and 3 years before they ever do anything, before they ever contact anyone, before they ever look up anything online. So it's a lot of people might be just in that early fact finding stage. It really depends. It's hard to say. So what I'm going to do first is talk about what you need to do. And that is, I think, pick an approach and pick a situation. Don't let a situation or an approach pick you. If you do that, you usually find that you are reacting to things rather than taking control of a situation. And that can be really difficult. A divorce is already going to be hard on you. So it's good to have a good roadmap for what's going to happen. It's good to know, this is the approach I'm going to go with. This is how I'm going to deal with it. And to follow that, rather than just kind of be at the whim of what your spouse is going to do and wait for things to happen. When you react, that can be a lot more difficult from a stress management point of view. It can be a lot more expensive, and it can take you down a path you don't want to go on. So establish a plan, figure out what's right for you. How do you figure that out? Well, evaluate your situation. You need to do this on your own, and then you also should do it with an attorney, a professional, and figure out what fits best for you. So look at your situation. Do you have kids? If you have kids, you're going to have some kind of a relationship with your spouse or partner long term. So that's one thing to know. Is there domestic violence? If there's domestic violence in your situation, that drastically alters your options and what may or may not be appropriate. So that's another thing to know. Are there mental health issues that you're dealing with? That can also alter your situation as far as, maybe how reasonable the other person can be and what challenges you might have. So that's another thing to know. Are there other kinds of abuse? Substance abuse, emotional abuse? Do those issues come up? Because those are things you're going to want to take into consideration when looking at approaches to divorce. So kind of evaluate, what are my issues that I'm going to have to contribute to bring into the process that are my own, or what are the issues the other party might have? What are the things that are at play here? Second thing are, what are your goals? Are my goals to come through this process so I can be sitting next to my spouse at my child's graduation? Do I want to go through this really peacefully? A lot of people do. And that can be a challenge, but it's something that, is definitely worthwhile. Are my goals to get through this and not lose my 401k? Okay, that's totally a fair goal as well. So that's reasonable. Are my goals to get through this as quickly as possible and never see this person again? Fair enough. Okay. So what are your goals? And your goals are probably different than anybody else watching this, or maybe your goals are the same. It depends. Every marriage has different scenarios. And then you look at, all right, what factors do I have? What are my goals? And what process is going to help me get there? And then another thing to know is, are you and your spouse aligned on the goals that you have and what process? A lot of the time, the answer to that is no. Sometimes one spouse doesn't even want a divorce, and sometimes one spouse is the one that has substance abuse issues, mental health issues, and they're going to make the divorce really difficult. And you're like, I just want to get through it. So you may or may not be aligned. In other cases, you've both already talked. You've grown apart, we don't get along anymore, and we just want a peaceful, amicable end. So every situation's different, but those are the kind of things I want to talk to my clients about. I want to know, are we on the same page here, or is this a situation where we need to take a different approach? And those are things for you to evaluate and think about. And the more that you have answers to those questions, the easier it's going to be for you to figure out when you talk to your attorney or look at what approach might be right for you. So I'm going to talk about 3 different approaches. They are collaborative divorce. If you've looked into divorce at all, you may have seen that. It's a very popular buzzword right now. Cooperative divorce, which is actually the most common approach to divorce in Washington. And then the litigation approach, which is what it sounds like. It's litigation, it's court. So there's those 3. So I think I'll talk about actually collaborative first and get that out of the way, because a lot of people are always wondering, what does collaborative divorce mean? And collaborative divorce is it's like it sounds like it's collaborative, but it's a very, very, very specific process, and it's not for everyone. We do collaborative divorce, but we don't do very much of it. And the reason why is that cases need to be specifically screened into collaborative divorce. Collaborative divorce, it's a type of alternative dispute resolution. It can help couples avoid litigation completely, which is a good thing, and agree on a settlement without ever going to court. It's different from cooperative divorce because instead of really consulting privately with your attorney the majority of the time, you and your attorney and your spouse and their attorney will all sit down together at one big table and form a team. And on your team, there might be other professionals. There might be a financial person. If you have children, there might be a parenting coach. There might be a mental health person, and you'll form a team. So, one of the early steps in collaborative is figuring out who's on the team. But the team always includes the spouses and the attorneys, and you'll sit down in a series of meetings and work out a plan. And so collaborative is good in the sense that you work openly, you work as a team, you stay out of court. Some people will tell you a collaborative divorce can be less expensive. I can tell you that is not necessarily always true. It can also be more expensive because it's a lot of meetings with a lot of people, and it can stretch out over a period of time. However, it can be less expensive than litigating. That is definitely true. Not always, but sometimes. Um, it's collaborative divorce is not a good idea for the following people. It's not a good idea for anyone where there has been a lack of trust, where there has been domestic violence issues, where there are people that don't want to compromise, where there are people that don't want to be completely open and transparent about everything that's gone on and finances, where there's been emotional abuse, addiction, major trust issues, things that basically break down a lot of marriages. So if those things have happened and you're not really past them, it's probably not for you. It doesn't mean, and for some of those things, they necessarily screen you out of the collaborative process. DV necessarily screens you out, and a lot of other things do too. If you've had trust issues in the past, it doesn't mean you can't engage in the collaborative process, but it can make it difficult. A lot of parties find that it's very difficult to sit across the table from their spouse and talk about these things and work them out. Other parties don't find that, especially when there's children involved. Sometimes it's a good thing. They want to engage in that and they want to have those conversations. So it's not for everyone. Some of the positives about it are that you work together in coming up with a resolution with the team. You control the settlement, and the other thing to know is that there's zero option to litigate. So if you don't come to an agreement, one party can't say, "Oh, I'm going to go to court. I changed my mind." You could say that, but if you do, you are then opting out of the collaborative process. The collaborative process is a statutory process in Washington. So there's actually statutory law that governs the process, and all parties will sign a collaborative agreement when you begin. So if you are opting then out of the process, you have to start over with a new attorney because everybody's been open and transparent. Everyone's had these conversations together. So your attorney can no longer represent you in litigation. You would have to start over with new counsel. So that's a kind of not a great thing for a lot of people. Sometimes we'll have clients come to us that have gone through the collaborative process and it's failed and they have to start over. So that can be frustrating for them. Some people have gone through the collaborative process and it works great. It just sometimes takes a while. So that's a little bit about collaborative law. It's not for everyone. It can work really well for some, but it requires trust, openness, and a willingness to work with a team and work with your former spouse on the resolution. So, and we can come back and talk about it more later, but I do like people to know that it is an option. And also, too, the other thing to know is that if you are going to engage in the collaborative process, you need to have an attorney that's trained in collaborative law. I've done the collaborative law training and become certified in it. Another attorney in my office has done the same. There are attorneys who only practice collaborative law. but you cannot work with someone who has not been trained in the collaborative process because, like I said, it is a statutory process. So you actually have to go through those trainings and understand that process. It's a little bit different than other methods of divorce. So let's talk about now the most common, and this is cooperative. Most divorces in Washington are handled, I would say, cooperatively. And when I say cooperatively, I don't necessarily mean that everyone's cooperative and gets along and agrees on everything. Because the reality is, if you agreed on everything, you probably wouldn't be getting divorced. But it means that you've decided the purpose of a cooperative divorce is to minimize the time, the pain, the cost, and the destruction that the traditional litigation process causes people in courtrooms all over Washington. So you've decided, I'm going to go through this process. I'm going to use an attorney, but I'm going to be cooperative. And you decided in the collaborative process, I'm going to go through this process. I'm going to use an attorney and I'm going to do collaborative. And so this is not doing that process, but it is deciding I'm still going to be cooperative. I'm going to make every effort to keep my case out of court. I'm going to make every effort to do what I need to do to be honest and open and fair, but I am going to work with an attorney and I'm going to let them do a lot of the negotiation for me. And cooperative essentially centers on negotiation and avoids court as much as possible, but it does not take the possibility of court completely off the table. So that's a different thing. It also does not require entrance into a formal agreement. The collaborative process, like I mentioned, requires entrance into a formal agreement. So if you're not going to continue into it, then you are basically opting out. And when that's really important to know, because if you're opting out, then you have to get new counsel and you're no longer in the collaborative process. So in the cooperative process, it's informal. The attorneys will basically say, hey, we're going to try to be cooperative. We're going to try to be amicable. And these are the things we're going to do to accomplish that. But there's no participation agreement, and any attorney that works cooperatively can do it for you. The main advantage of one main advantage of a cooperative divorce is you don't have to fire your attorney and get a new one if the process doesn't work. You can stay with the same attorney if you end up needing to go to court for something. One thing when you start a cooperative divorce, it's all about tone. You might want to start out and say, we want to start this process amicably. We don't want to fight. We want to keep costs low. We want to agree to a mutual exchange of information. And hopefully both parties will want to do that. If one party decides they don't want to do that, you then might need to seek court intervention to get support or discovery or anything of that nature. You hope you're not going to have to, and you usually take the tone saying, I don't want to have to do that, but the door is open if you need to. Divorce, here's the thing about cooperative divorce. People think divorce has to be contentious. It doesn't have to be. And the idea of cooperating through that process with counsel is that you stop that. Every year in Washington, thousands of people get divorced and they utilize the cooperative process. The way that we usually start that process is saying we're going to exchange information. We're going to agree to do so by such and such of the date. We're going to exchange information and exchange proposals. If that doesn't work, we're going to go to a mediation. But that mediation looks very different than mediation in a collaborative process. It's more of a traditional mediation. It's what we would call a shuttle mediation. And that is where you and your attorney would be in one room, the other party and their attorney would be in the other room, and a traditional attorney-trained mediator would go back and forth and shuttle back and forth between the two rooms and carry offers and proposals back and forth. And this kind of mediation is extremely successful. In my experience and in Washington divorces, more than 90% of cases settle in these one-day mediations. So instead of a series of meetings like you would have in the collaborative process, you've gone through the process, you've exchanged the documents ahead of time through counsel, you've prepared your proposals, and then you have a one-day mediation. And that day, you have privacy in your room, the other party has privacy and confidentiality in their rooms. So you each get private information and agreements, and then the mediator shuttles back and forth and usually does what's called an evaluative mediation. So they evaluate your position, they give you advice as they go, and they help the two sides come closer together and basically get the deal done. So it's a shuttle mediation rather than a round table situation. So that is hopefully how things work. And then after that, you have a deal, you have a settlement, and those orders get executed between the attorneys and entered, and then you get divorced without ever going to court. That's how it ideally happens. Sometimes more of a hybrid model has to happen, and we'll talk about that in a few minutes. Because cooperative divorce is really the most common, I think it's important to talk about some tips if you want to consider a cooperative divorce. One, and this is the hardest thing to do, it is the hardest. Don't bring your emotions to the table. Just don't do it. Nothing brings down the cooperative process faster than bringing baggage and emotions and blame from the past. Sometimes clients want to talk about all these things that happened and everything that happened leading up to this point. I want to know what happened because I want to have the backstory and I want to understand where my client's coming from, but I don't want to keep talking about it in the context of the case. I don't want to keep telling the other side about it, because all it does is it pushes buttons and it reopens old wounds. It costs more money and it usually isn't relevant. If you don't have kids, and you're not going to have an ongoing relationship and see this person, it's not really relevant what they said or did to you, because you're not going to see them anymore. If you do have kids and you have concerns about this person's behavior around your kids, that's different. If this person lied and hid money, well, that's going to matter, because we're going to need to find out where the money is to divide it. So it's really all about taking the emotion out of it and getting down to what really matters. But the point of the communications that you have throughout this process is all about being resolution focused. We're trying to get through the process in a cooperative way. So it's important to talk to a therapist, someone like Melissa, and talk about the emotions that you're having. And it's not like I don't care, I don't want to hear. I do. But I also, sometimes clients will say, well, why aren't you telling the other party, that he did this to me 5 years ago? Well, I'm not telling the other party that he did that to you 5 years ago, because the other party is going to say, why are you telling me that he did that to you 5 years ago? It's not helping us resolve the case cooperatively. It's bringing up things that you're still really ticked off about. And it doesn't mean you can't be mad and still be cooperative. It just means try to keep those things in a different arena and try to not bring them to the negotiation table when you're trying to come up with a proposal.
And
So
Michelle, I was just
yeah,
going to say, of course, there's a lot of emotions involved
yeah,
when it comes to this process.
it
And
should be.
right. And so it really is so important that you do have, your support network lined up so that you can, have strengthening your coping before you're going into these meetings, before you're going into a mediation, before you're going into a meeting with your attorney. Have your support network in place, have supportive people around you, work with a therapist so that you do have a place to, process and explore all of those emotions that are coming up for you right now, so that you can save yourself time and money while you're dealing with your case, and not having those emotions enter that arena. Because like Michelle said, that's
Yeah,
not going to help resolve things. It's not going to help your bill, and it's not the most productive as well. So it's a lot
no.
to make sure you have a therapist and a strong support network.
Yeah, one of the things Melissa said is totally right too. People think about divorce being really expensive, and it can be. And people ask me, how expensive is this going to be? And a lot of the time I tell them, well, it's as expensive as you and your spouse are going to make it. It's not my choice how expensive it's going to be. It's as expensive as, how much you're going to fight and how much you're going to need to process and talk about. We're not going to make it that expensive. We're going to be as efficient as we can, but we're also going to do what we need to do. But what Melissa said about, having other outlets and support is so important. Sometimes I've had clients in the past where they don't have other outlets and support, so they want to talk to me about it. And I'm going to talk to you. I mean, I've even got some good ideas, but I'm not a therapist. So I can tell you legally what you can do, and I'm happy to sit down and talk about all of this stuff. I'm happy to. And I've been divorced, so I've got stuff I could talk to you, but I'm not a therapist, so I don't have the tools to tell you how to get through it. And you're going to pay more to talk to me about it than you're going to pay to talk to your therapist, who's going to actually give you concrete tools to work with and help you process a lot better than I can. So a lot of the time divorce becomes more expensive when you don't have a support network. And I've had times where I've even told clients, you know, what are your insurance options? Or if you don't have insurance that covers therapy, because that can be also too really difficult to find a provider that's in your network, you can always, if you have someone who's out of network, you can submit to your insurance. Or even if you're just cash paying, it's far cheaper than cash to cash pay a therapist than it is to pay an attorney to talk to you about things that are non-legal issues. And it's not that we don't care, because we really do, but it's a definite reason why divorce nationally is so much more expensive, is not having an outlet for those skills, to work on those skills. So anyway, that's definitely notable. Taking your emotions off the table will save you money, and it will also help resolution come a lot faster. I can't stress that enough. The other thing in cooperative divorce, another tip number 2 really is differentiating between wants and needs. So everybody wants, well, not everybody, but a lot of people might want that one thing that you got for a wedding present like 14 years ago. But do you need it? I mean, are you really going to spend a half an hour to an hour fighting about it in a mediation? Because if you do, you just spent like $1,000 an hour between the 2 attorneys and the mediator fighting about, like, I don't know, a set of dishes that somebody gave you 14 years ago. That is not a good usage of your time. And I will tell my clients, like, do you really, really need this? No, you want it. And do you want it because you want it, or do you want it because it's going to make him or her really mad? Let it go. You don't want that. You don't need it. You want it. And number one, why do you want it? Let it go. Start over. Go buy yourself something new. It's not worth it. Wants and needs, differentiate between what you want and what you need. It's different when a client is like, you know what, no, I need part of that 401k. I don't have one. I need one. I've got 15 years to retirement. I need that. Well, then fine. We are going to fight for that. That's totally different than fighting about, I had a case where somebody insisted on fighting about old movie posters once. I'm not kidding. And it was absolutely insane. But you know what? And he didn't need them, and he didn't want them. He just wanted to make his spouse mad. And so I try to caution people, don't do that. Think about needs and wants. Let's really have a real conversation about this. Do you need this, or do you want it? If you want it, why do you want it? And let's talk about what's really valuable to you in your case. A lot of times, and this triggers into the emotional part of it too, you can really get stuck on things that are not helpful to you. So that's really, really important. I identify too what you're willing to give up for the sake of cooperation. In the cooperative process, when you're thinking about needs and wants, look at what are the things that maybe you both want, because there are going to be things that you both want, and think about what are the things that you're willing to compromise on that might not be as important to you, to get something done. And then you might be surprised. It might trigger your spouse being willing to compromise and cooperate and give you something that you want. And then that will, oh my gosh, we move past this and then we move on to something else. Those are the kind of things that move a case forward as opposed to holding them back months. You would be surprised. And the other thing too is when you're looking at needs and wants early on in the case, take a long-term objective look at your finances. I encourage my clients early on in the case, if they don't have a financial advisor, I will make a referral to one. And a financial advisor too is not just for somebody who's wealthy. A lot of people think that. They're like, oh, I don't need a financial advisor. I don't have a high net worth, or I don't have anything but my house. Well, actually you do need one, or you at least need to talk to one, because your financial picture is going to look very different after divorce. And if you have children, you need to think about what it's going to look like for them and what your planning is going to look like. So you need to also think about, these are the assets, and we need to start thinking about what assets do you need to take away in the divorce versus what you want, what assets are more valuable for you to retain. And you might want to think about, your overall picture. Maybe it's more important for you to have, home equity. Maybe it's more important for you to take more of an IRA or a 401k. So I encourage you to take stock of your financial picture up front. We can help you do that. An attorney can help you do that. But a good attorney will also help you get on board with the financial team early on if you don't have one. And a lot of people don't have one. It's just not something a lot of people think about. It's also too to determine. Part of that is budgeting. We have you do a financial declaration early on and take a look at how much is it going to take for me to live independently now, as opposed to in the marital community, and to really take a look at how much you need, and also take a look at how much the other side needs. Those things are very important. The next tip number 3, is being willing to consider various options. It sounds unlikely. This might sound unlikely, but your spouse might actually have good ideas. They might have an option where somebody might say, oh my gosh, maybe we should sell the home. This is very common. A spouse might say, I think we should sell the home and divide the proceeds. And you might be like, oh my gosh, they want to take my home from me. Because you have it in your mind that you're going to stay in that home until you die. A lot of clients will say that. And you might not have evaluated that maybe this is a great time to sell and maybe you can't afford the home anymore. But maybe if you sell it, you both could walk away with a lot of money. So being willing to look at various options doesn't mean you're doing it, but willing to consider options that are not necessarily ones you came up with. It's important. Keep an open mind. Consider your options. Attorney can prove extremely helpful here as well. What I like to do and what many attorneys like to do is I'll give my client a few different settlement options. So here's option A, B, and C. We could divide things 3 different ways. You might not like them all, but these are 3 different ways that I think might work for you. Let's talk through them all. And don't react emotionally. Let's talk about what really meets your objectives. The next thing too is considering your spouse's needs and wants. Nobody wants to hear that in a divorce, but if you want to cooperate and you want to avoid court, you're going to have to give a little. And so considering what are the things, you know them, you've been married to them, so you know what's important to them. What are those few things that if you might give a little bit, they might take some of the pressure off and say, all right, I'm going to agree to what he or she wants. Give them something they want. Give them something you know that they want, and or something that they need. You might know that so and so really needs to go back to school, so you might say, I'm going to be willing to pay spousal support for 2 years for him to get through a master's program, or I'm going to be willing to he has a year left on his car loan. I'm going to be willing to pay that, or I'm going to be willing to give her the better car because she's going to be driving the kids around. Start thinking in terms of what's going to get the deal done and what can I live with, rather than how can I punish the other person. That's what gets you through the process. Really, by fostering a cooperative environment as far as give and take with your attorney and with the other attorney, you're going to work towards a respectful and an amicable resolution and stay cooperative rather than going litigation. That's the last one we're going to talk about, litigation. I've litigated many, many cases, and I can tell you, people say, how much is my divorce going to cost? And I can tell you, again, how much you're going to make it cost. Your divorce can cost, divorce in Washington, average divorce with both parties having attorneys and having very little conflict, anywhere between $6,000 and $9,000 per party. When you start litigating and getting more and more expensive, I finished a case this fall where each party spent like $120,000 or $130,000. And why? Because every step of the way it was litigated for about 2 years. And that is completely unnecessary in most people's situations and completely outrageous. But the bottom line is it's not outrageous for the amount of litigation and time that it takes. That doesn't happen a lot, but a litigation divorce is usually a situation where there are major issues, either major financial issues, major custody issues, major relocation issues. This was one where a parent wanted to move to India, and there's just all kinds of crazy things going on. But the reality is a litigation divorce is what it sounds like. It's where really everything that happens takes place in court. So any decision that needs to be made has to happen through the court. Nobody can agree on anything. They can't agree on a parenting plan on a temporary basis. They can't agree on temporary child support. They can't agree on who's going to pay what bills temporarily. They can't agree on anything. So everything has to be brought to the court to make a decision. And I cannot stress to you enough what a difficult way that is to live throughout a process, because the divorce process is really, in a litigation case, it's going to take you 9 months to 18 months, maybe even longer. So you don't want to go down that road. If you end up in that situation, sometimes you don't have a choice. And if you have to litigate it, you just do the best that you can. But litigating your entire case is very difficult. What can happen very often is that you litigate part of the case and then you realize, oh geez, this is not the way to go. And a lot of people start out and they want to litigate, they want to, whatever, and and maybe they have to because maybe it's a safety situation and they need a restraining order right up front. And then they realize, okay, now we can kind of de-escalate things. Another thing that's really important to know is that every case in King Pierce and Snohomish County has what's called an ADR requirement. ADR stands for Alternative Dispute Resolution. That means before your case can go to a trial, you have to mediate or arbitrate or engage in some kind of dispute resolution. However, that can be waived. That is waived if there's domestic violence, and that is basically because they don't require the parties to be in the same space, although there are ways to get around that now because we're doing Zoom mediations and all kinds of things like that during the pandemic. So I would say that it's common for cases to, number one, either start out as litigation cases and then kind of taper off. Maybe the parties mediate, maybe everybody then starts to be more cooperative through counsel because the costs have gotten out of control and they don't want to keep doing that. Or it can be common to start out cooperatively or even collaboratively, and then we realize nobody's on the same page and one party is refusing to do anything, and somebody actually has to go to court to get some relief. And that's not a bad thing either. Sometimes that has to happen. So, sometimes you get a little bit of both, and that's more of a hybrid approach. And sometimes part of the case can be handled in litigation, and then you can go back to mediating, final orders. That's not uncommon at all either. And that's a very doable and reasonable way to resolve things. Where cases really get expensive is if you have to actually go to a final trial in your case. And it's notable too that I would say less than 95% of, less than 5%. So 95% of family law cases settle with no trial. 5% or less is my estimate of cases that actually go to a trial in a family law case. So yeah, so those are really your three main approaches to divorce and separation. You've got collaborative, you've got cooperative, and then you've got just full on litigation. And then you have that hybrid model that really, is in between. And I think the most common is definitely cooperative, and the second most common is a hybrid model where you might have to go for one hearing here or there, but your whole case is not litigated. And hopefully for you, you sort of think about at the outset, what do I need to do here? And where do I fit into this? And what makes the most sense for me and my family? Because it's not the same for everyone. It's just not. So
I just wanted to remind everybody, if you do have any questions, please go ahead and put those either in the chat or the Q&A. I don't see any questions yet, but we do have quite a few participants, so that makes me think that we're answering your questions, which is wonderful.
Even better.
But we'll give a couple more minutes to collect any questions in case there are any. So just a reminder to go ahead and put those either in the Q&A or the chat.
Great. Well, if we don't have any, what I'll do is, Melissa, do you have anything else that you want to add about the different approaches?
No, I work with clients who are considering going through divorce and having a hard time determining whether they're looking to go in that directions or looking to try to repair the relationship. And I think sometimes people are very afraid of costs of divorce. Sometimes people are very afraid of court. Sometimes people are very afraid of, what Michelle's talking about with litigation and, how things could spiral out of control and, a lot of anxiety, I think, related to all of that. So I think it's really helpful to understand that there are different ways to approach divorce, also from the emotional perspective for clients or for people who are contemplating it and perhaps, in ambivalence because of not only all the emotional aspects, but sometimes people have a lot of really complicated logistical aspects in their marriage that makes it feel impossible to untwine, whether it's custody or children or finances or all of it. I think people get really overwhelmed by the process. So understanding the different approaches to the process, I think, to me as a therapist, seems really useful for people who are in that sort of early state of trying to determine what they're going to do next.
Yeah, and I think it's also notable too that, the different approaches, while I talk about them specific to separation and divorce, when you have something like, I think a lot of people think about relocation too. Relocation is a very common thing that comes up. You can handle a relocation matter as well without litigating. You can handle a parenting plan modification without litigating. You can handle that cooperatively. You can handle a lot of different family law issues without litigating. So it doesn't have to just be, you know, specific to a divorce. You can handle many of those issues without litigating. A lot of the time people think, well, we have a disagreement about what's going to happen, so we have to litigate. And that is not the case. So these different approaches can be utilized in a variety of different family law actions. If there's an action like contempt, like somebody's in contempt of the parenting plan, that's a little different. That's like a one-off situation that you have to litigate. But other family law issues, you don't necessarily have to litigate. You can always look for a cooperative approach. And then if it doesn't work, okay, fine. But I think it's important to think about, you know, when you approach things, what tone you want to take, because that can really set things in motion. But it doesn't just apply to divorce. We have a lot of clients that are post-divorce that come back and need to make a change to their plan or want to move and relocate, and that's when these things apply.
Yeah. Do have a couple questions now, so I'll go ahead
Okay.
and ask those.
Sure.
Can I still get his medical insurance, which is Premera Blue Cross, if I separate legally rather than divorce?
That's a great question. Guess what? It depends. I'll tell you this. There's twofold twofold answer to that. The first part of that is this. This is really important. I'm actually, whoever asked this, great question. So and I just actually spoke to someone about this yesterday. So everybody worries that when divorce is filed, I'm going to lose my insurance. Not the case. When a divorce case is filed in King, Pierce, or Snohomish County, an automatic temporary financial restraint goes into place that requires insurance and financials to stay basically status quo. So if you're on insurance, you get to stay on that person's insurance during the case, whether it's a legal separation or a divorce, you get to stay on insurance. So nobody can take you off insurance during the case. And like I was saying earlier, a typical divorce case or legal separation case can go anywhere from 6 months to 9 months to a year. So insurance isn't going to change during that time. This question might pertain, so that's temporary insurance. This question might pertain to post-divorce or post-legal separation insurance. And I think you were asking about legal separation. That depends. Different providers, and if you're talking about Premera Blue Cross is going to be specific to whoever the plan administrator is, and it's going to be specific to your employer. Your employer is going to have a policy that's going to say, when you're legally separated, once a decree of legal separation enters, can you keep that person on benefits? A lot of the time, the answer is no. And the reason why is because if you could get legally separated and you enter a decree of legal separation, what happens then is you file taxes separately, and for all intents and purposes, you are actually legally separated. So to carry you on benefits would basically kind of allow for double dipping. In some situations, then, you know, you got the temporary insurance until legal separation is finalized. But if legal separation is finalized, then it allows for a benefit change. You would be eligible for COBRA, but you wouldn't be eligible to stay on the Premera benefits. Some other insurers though, and other plan administrators would allow you to stay on. So what you really would want to do is you'd want to find out the specifics of the employer plan who is carrying the Premera. When divorce happens, you always have to leave the plan benefit. You're COBRA eligible, but you have to leave the plan. It's not a choice. But legal separation, it can vary. One thing that's really important to know, though, is divorce or legal separation is a life-changing event. So even if it's not open enrollment, you can absolutely get a plan through Washington Health Plan Finder and through the exchange no matter what time it is. So no matter what time of year it is. If your decree enters, you can get a new plan. It's a life-changing event, so you can always get a new plan. And this is also important too. People ask about insurance. Sorry, I could talk about it forever. It's also important too, because when you're starting to think about your plan for divorce and separation, you want to know ahead of time if you're going to be able to stay on benefits or you're going to need to get new benefits. And the reason why is because you're going to want to anticipate what those costs are in your post-divorce budget. Because if you're looking for maintenance, you're going to want to factor that into your maintenance award. If you're looking for property division, you want to think about, okay, I've got to think about the fact that I'm going to be paying for insurance when maybe I was on my spouse's insurance before. So those things are all very important. So long answer to a short question.
There's a couple more. There's a question about how to contact me. So the answer to that is at the end of the webinar here. I'm going to post a slide with both of our contact information, so you can grab that there. And then there's another good question here about high conflict divorce. So the question is, do most high conflict divorce cases go to mediation? I anticipate mine would, and I would expect an all-day mediation would be expensive, but how expensive?
Yeah, I mean, your high conflict case has to go to mediation. You can't not go to mediation unless you're going to agree without mediation. But your high conflict case is not going to agree with without mediation. Trust me. And I've done these high conflict mediations. This isn't going to be you, but I was once in a high conflict mediation a couple of years ago. This is pre-COVID, where we were at the mediator, one of my favorite mediators, thank goodness. But we were at this mediator until 1:30 in the morning. But we settled the case, and I can tell you this, and we did not think we were going to settle the case. I can tell you this, and the mediation started at 8:30 in the morning. So you can bet that was an expensive day. But you can also know that that day was far more cost effective than a 2-week trial. A 2-week trial that would have cost these parties $65,000, $70,000 each. A 1-day mediation, that sure, it was an expensive, $5,000 or $6,000 day, but you tell me what was more cost effective, the 1 day. But I can tell you this, yes, your high conflict case will go to mediation. The question is, when will it go to mediation? Will it go to mediation after many, many months of intensive high conflict litigation? Or will it go to mediation earlier in the process when maybe you get an agreement to mediate earlier rather than later? If so, that would be a lot better for you, because it would save you on time and energy and effort. And by the way, all day mediations don't go till 1:30 in the morning very often, and not that many. That's not usually typical. But an all day mediation often will start at 8:30 or 9 in the morning, and will go to 6:30, 7:30 at night. That's not uncommon. And then you're paying for your attorney's time, the other party's paying for their attorney's time, and you're typically splitting the cost of the mediation 50-50. That's so both parties have skin in the game and are paying for the mediator's time. That is an expensive day, but it is far less expensive than going through a trial and trial prepping. And most of the time, what you do is you set the mediation early enough so then you avoid having to pay for trial preparation if you settle. That's the goal. I say that your case will go to mediation because mediation is required. There's a case schedule that issues, like in King County, that requires mediation before you can go to a trial. And so what I always like to try to do is say, how can we get through everything we need to get through in this case to get to mediation? And when we get to mediation, even in the most high conflict cases where people literally hate each other or could not agree, I'm very confident that I will get you to settle. Very rarely do we not settle. It might be a long day, but there'll be snacks and beverages and you will settle. And it's a lot more cost effective than a trial. And it's those kind of high conflict mediations where you're really glad that you're in one room with your attorney and they're in the other room with their attorney and you don't have to see them all day. Those are not cooperative. Those are not collaborative cases.
It's hard to give a range, but I wonder if you could. It sounds like they're kind of trying to figure out, what does that mean for what a 1-day mediation? Do you have a range of what that would be in terms of cost? I know that's kind of hard to.
That's a ridiculous question. No, I don't know, because it depends on what attorney you have. I mean, that's asking me to say what attorney you're hiring and what mediator you're hiring. I can tell you this. I mean, that's a really hard question because I don't know. I mean, I don't know what mediator you're hiring. You could hire a mediator that's $300 an hour or a mediator that's $500 an hour at JAMS. And you could have, so that makes a big difference. I mean, if you're in a 10-hour mediation with $300 an hour mediator, it's $3,000 split by 2 people. That's $1,500 each. If you're in a mediation with a $500 an hour mediator, which would probably be a retired judge, which is necessary in some cases, then you guys each pay $2,500 each for 10 hours. And if you were in a longer mediation, some people will charge you time and a half if it goes into the evening. Some people won't. Also, too, then you're paying your attorney time. And the other thing to think about too, which is really, this is the part why I don't like to get into estimating, but I do want to tell you, is how complicated your case was also depends on if there was a lot of preparation materials that the mediator needed to read ahead of time. Like, did you send over 2 hours worth of materials for the mediator to read? Because then you got to pay for them to read that. Also, too, how many hours of time did your attorney have to spend preparing for the mediation and putting together your financial spreadsheet, your parenting plan? So it's just really hard to estimate. But for that 1 day, I can tell you, think about it like 8 to 12 hours, you're paying for your attorney time and half of the mediator time. It
Right.
is far more cost effective and far better than the emotional and financial toll of like a 2-week trial, especially if it's being done via Zoom. Trust me, you don't want that. So anyway, I hope that helps. And Melissa did already put up some
Yep.
really helpful contact information. If you have other questions that we didn't answer, we'll do another webinar next month that we'll talk about some other helpful topic. But feel free to reach out to Melissa. She's a wonderful resource. I can't tell you enough how helpful she's been to so many of our clients and other clients of her own. Feel free to contact me or our team. We're happy to talk with you. And even if we don't talk to you, best of luck. And I really, really cannot stress to you enough that choose a process. Don't let the process choose you. Really think about the tone that you want to take. And I don't encourage anyone to say, start off the bat, I want to take the litigation road. I would tell you that, and as someone that does litigate when necessary, but I'm also someone that can tell you that litigation is expensive and stressful, and don't go that road unless you really need to. Even if you have high conflict situations can be dealt with cooperatively, and then you litigate if you need to, because that option is still there for you. So I hope that's helpful. I hope that you got some good information today, and thanks for joining us.
All right. Thank you, everybody. Take care. Hope to see
All
you
right,
soon.
take care.
Bye-bye.
Bye.